Hi, I'm Gilbert Ambler, independent program attorney for U.S. LawShield of Virginia. This week, my office joined thousands of other patriots in Richmond for a peaceful day of lobbying our elected representatives. Despite the cold, and it was cold, and despite Northam's attempts to cause fear and to ban weapons around the Capitol, the turnout was impressive. Estimates placed the crowd between 22,000 to 50,000 people, and I have to tell you, it was a diverse crowd with some of the nicest and some of the most polite people I have ever been around. However, this crowd did not seem to faze the legislature, who continues to reject pro-gun bills and press forward with anti-gun measures. There have been several measures that have already passed through the Senate. This is important because the Senate was viewed as the most likely place to stop these bills before they became law. After they become law, it will take challenging them and winning in court to stop them. I want to reiterate, however, that these bills have only been approved by the Senate, the House has not yet approved them, and they have not yet been signed into law. So far, the Senate has approved SB 69, or the one handgun per month bill. This bill has a notable exception and does not apply to those who hold a valid concealed handgun permit. Next, the Senate passed SB 35, a dangerous bill that undoes some of our state's preemption protections. Simply put, if passed, gun laws will no longer be uniform across the state, allowing localities to ban weapons at certain events and in specific locations. This is worrisome to gun owners, as they will now need to learn the local regulations in each locality they enter. What might be permissible in one county may suddenly become illegal in a neighboring county. After that, the Senate passed SB 70, which requires a background check to be completed for every private sale of a firearm. No longer can you sell a gun to your family member, best friend, or hunting buddy without the government having a hand in the transaction. With the way the bill is currently worded, temporary loans, such as to a friend at hunting camp, will still be permitted. If passed, there is also no word on how law enforcement will establish whether a private transfer took place before or after the law was implemented. Finally, the Senate considered and passed SB 240, which is a red flag bill. SB 240 allows a Commonwealth attorney or any law enforcement officer to apply to a court and receive an emergency substantial risk order. These orders criminalize the possession of firearms by the covered. Additionally, the orders provide for the seizure of firearms. The order initially lasts 14 days, but can be extended up to 180 days. While other states have passed similar measures, SB 240 in particular is concerning to Virginians. It is unclear what level of evidence will be needed for law enforcement or a Commonwealth's attorney to receive such an order from a judge. What is clear is that you only get the chance to argue your side of the case after your weapons have been seized by the order. While the courts have always said that due process is a flexible standard, this seems like a blatant disregard for gun owners' due process rights. It raises serious Fourth Amendment unreasonable search and seizure concerns, and it also obviously impacts state and federal protections on the right to keep and bear arms. Finally, it logically has some holes. For example, pursuant to Virginia Annotated Code 37.2-808, 809, and 814, a judge can already order emergency treatment for someone the court finds to be a threat to themselves or others. If someone is truly a threat, doesn't it make more sense to confine them for treatment rather than only confiscate their weapons? That is why some have said that this is not about safety, but is really just gun control for the sake of gun control. Stay tuned for more updates from us as things progress in Virginia. In the meantime, stay safe, and if you have questions about these or any other proposed bills, call U.S. LawShield and ask to speak with an independent program attorney.